We start with the basics. Generally, you must preserve harmful errors to have a chance at prevailing on appeal. With one exception, you must preserve the error. If you don't, it's kind of like the soup guy on Seinfeld. No appellate review for you. There are generally 7 ways appellate courts assess error. Preserved. This is the category most errors fall into. A preserved error may be deemed harmful or harmless, but in either case, the error must have been preserved to get appellate relief. Unpreserved error is generally fatal to appeal, except in cases of fundamental error. Harmful error, these errors are, if preserved, are likely to result in a reversal unless the error was harmless.
The appellate courts are error-correcting courts. They're not there to decide law in the abstract or to decide how they think a case should have come out if they were ruling on it originally. They are there to correct errors of the trial court. And so if they reverse a case, what they're doing generally is they're saying to the trial judge, you made a mistake, it was harmful, and we're going to correct your mistake. Well, it's a little hard to tell a trial judge they've made a mistake that you're correcting if the trial judge wasn't asked to address that issue or that mistake. And so if the court is there to correct errors, they're generally going to say the trial court didn't err if they weren't asked to do something that you're now asking us to reverse them on.
Harmless error review. This is sort of like the even if error. Even if the court erred and assuming the error was preserved, the appellate court will affirm. Harmless error, here the appellant always loses because even though the error was harmful and preserved, it did not vitiate the right to a fair trial. This frequently comes up in cases of the erroneous admission of hearsay, for example. One
of the purposes of recognizing harmless error is we like to say you're entitled to a fair trial, you're not entitled to a perfect trial.
Mm-hmm.
So in a simple example, if you have 10 witnesses who all say the light was green in a case, and one of the 10 shouldn't have been allowed to testify to it, the court very well will say there's no reasonable basis on which that would have changed the outcome of the trial, and therefore we're not going to reverse on that basis.
Invited error is what I would call the doomsday error because the appellant always loses. Invited error bars appellate review. And this is true even if the error was fundamental. An appellate court will not reverse where the error was invited. Fundamental error, this is the one exception to preservation, and it's sort of like an escape hatch of sorts.
I don't recall a single case where in a civil case we decided some error was fundamental. It really has to go to the very heart of the case and make it untenable for the decision to stand, even if the error was not preserved. I don't think it was at issue because I think it was preserved, but it's the kind of error that probably could have met that standard.
Fundamental error is very rare in the civil context. Fundamental error is waived when the error is invited. Then finally, cumulative error. And the idea behind this is that while any one preserved error by itself may not warrant reversal, several taken together might. I can think of this as sort of like a death by 1,000 cuts. Any one error by itself will not result in a reversal, but several errors might. This type of argument only works if the errors are preserved and are harmful.